Did you know that you could get legal status and a green card when you're a victim of violent crime and you help law enforcement? Today, we're going to discuss what is the U visa, what benefits can you get from a U visa, what are the requirements to apply, which of your family members can get a U visa with you, 5 mistakes to avoid that can get your U visa denied, how to use a U visa to get a green card, and how much does it cost and how long does it take.
Calificas para ser legal, quieres saber, solo llama al abogado Andrés Mejer.
So, what is the U visa and how to get a green card from this process? Let's start with some general information. U visa was created to help law enforcement get criminals off the street. Immigrants are typically afraid to speak to the police, so even when they are victims of a crime, they believe that they might get detained or they might get arrested or they might get deported. So the U visa will not only protect them, the victim, in this case you, but also your entire family will get legal status along with you and ultimately a green card. Now, only 10,000 visas are issued each year for the U visa, so it's taking over 4 years to get a U visa from the date that you apply. What are the benefits of a U visa? I'm glad you asked. The U visa allows you to remain legally in the US for 4 years. After 3 years, you can apply for your green card. So it is a path that ultimately will result in citizenship. The U visa also is extended to certain of your family members. For example, your spouse or your minor children, by minor I mean under 21, who also have no immigration status in the US. If they were born here, obviously they don't need this. Now, the U visa gives you work authorization, a social security number, and with those two, you can then apply for a driver's license. You can immediately apply for some public benefits and you don't have to worry about the public charge requirements for a green card. What are the requirements for a U visa? Well, first, you have to be a victim of a qualifying criminal activity that occurred in the United States. Now, the crimes don't need to have been completed. For example, if someone attempted to commit a qualifying crime or solicited or conspired to commit these crimes, that is sufficient. Let me give you some examples and some categories of different crimes. So first, violent crimes: murder, manslaughter, vehicular homicide, robbery, assault, domestic violence, stalking. All of those are violent crimes that qualify for a U visa. Then there's enslavement crimes. So criminal restraint, kidnapping, abduction, forced labor, slavery, human trafficking, indentured or debt servitude, and false imprisonment are all qualifying crimes. Third category would be sexual crimes: rape, incest, sexual trafficking, sexual assault, prostitution, sexual exploitation, and female genital mutilation. The fourth are obstruction of justice crimes like perjury, witness tampering, withholding of evidence. And the last category, and the newest, is fraud in foreign labor contracting. So you need to be a victim of one of those qualifying categories of crime, or a crime that's substantially similar to one of those 5 categories that I explained. Secondly, you have to have suffered serious physical or mental abuse because of a qualifying crime. It's not enough to just be a victim. You must have suffered substantial physical or emotional abuse due to the crime. Immigration will consider how severe the injury was, for how long the abuse occurred, and how likely it caused you permanent harm. For example, if someone comes up to you and pushes you, well, that could be an assault. You call the police, maybe they get arrested, maybe they even get convicted. But you know, for a little bump, that isn't really significant or serious harm. Now, if that happened on a regular basis, if sometimes actually you were beaten and you were beaten dramatically, and in this incident there wasn't as much abuse for this incident, but there's a prior history, well, that's a different story. 3, you must have information about the qualifying crime. If you are a minor or disabled, a parent, guardian, or friend can assist law enforcement on your behalf. 4, you were or will be helpful to law enforcement in the investigation or prosecution of the crime. If you are a minor or disabled, a parent, guardian, or friend can assist law enforcement for you. 5. A government agency like the prosecutor, the police, investigating the crime signs a law enforcement certification for you known as Form I-918 Supplement B. And lastly, you are admissible to the United States. However, if you are inadmissible, a U visa gives you the option of applying for a waiver by filing Form I-192. The more significant the inadmissibility, the stronger your case needs to be on the other factors. The waiver can cure things like illegal entry, orders of removal, and some crimes. So immigration is going to look at it in the totality of circumstances. If you entered without permission, illegally, and that's the only issue you have, yes, you need a waiver, but that isn't a significant negative strike. If you have multiple drug charges, if you were convicted of domestic violence in the past, or robbery, or DUIs, so again, immigration is going to look at what did, in totality of the circumstances, let's look at all of the elements, how much you suffered, what was the crime, how helpful were you, who did you take off the streets, and in comparison to your past criminal conduct, and then decide, do you deserve to get it or not? Now, which of your dependents can get a U visa with you? Well, for every dependent, you need to fill out Form I-918 Supplement A for each dependent. If you, as the victim, are over 21 years old, then your spouse and your children under 21 can receive derivative U visa status when you are approved. So you file when you're approved, your derivatives get it. If you, as the victim, are under 21 years old, so if you're an adult, if you're over 21, it's your spouse or your children under 21, who obviously are not U.S. citizens or lawful permanent residents, because otherwise they would need it. If you are a minor under 21 years old, then your spouse, your unmarried children, again, that's the same, but if you're under 21, your parents can receive this benefit, and any unmarried siblings you have that are under 18. Let me give you 5 mistakes to avoid in the U visa process, and I see these way too often. You know, when the longer we've been doing this, the more clients come to us after they've been to another attorney. Sometimes mistakes were made, sometimes they never did anything. Others, they filed and then they didn't provide the appropriate information, and now they need to respond and they're not sure what to do. So the first common mistake that I see others, either with an attorney or without an attorney, is not including the law enforcement certification with the initial application. This is Form I-918 Supplement B. You will be denied 100% of the time if you don't file the law enforcement certification. Now, years ago, people would file for a U visa and then supplement it with the Supplement B. Nuh-uh. I never did that. I never recommend that, because if you can't get the Supplement B, then all I'm doing is telling immigration where you live. And if you get denied, they can come pick you up. That's not a smart play, in my opinion. Second, not including all your grounds of inadmissibility in the Form I-192 waiver. Look, a U visa has a built-in waiver, but if you don't ask for things that make you ineligible, they're not going to approve it. You have to disclose everything that might make you ineligible. If you killed somebody, it's pretty clear that makes you ineligible. It's also pretty clear you're not likely to get approved. But what happens if you have multiple entries? What happens if you have prior applications, or maybe there's allegations of possible fraud? You need to include everything. It's why we suggest doing a full background search with the FBI and all 7 immigration agencies to make sure we catch everything. Third, too often I see dependents left out of a petition and missing their opportunity. Let me give you an example. This is a case I've had. Let's imagine that you were a victim of a domestic violence, for example. Say it was, 17 years ago. Now, today you have 2 kids, you're with your significant other for the past 15 years, you live together, but the 2 of you are not married. You file for U visa for just you. Well, your kids don't need it because they're U.S. citizens, they were born here. But your significant other could be included if you guys get married. And why not get married? You have 2 kids and you're together 15 years. It's your spouse in everything that matters, but not in the eyes of the law. Another example, not including your minor children when you applied, or after you apply, your kid's married before the petition is approved. So your kids have to be unmarried and under 21. If after you apply, your kid's married, they get disqualified. I've seen 2 cases like that, and it is a shame. 4th common mistake to avoid: giving up on requesting the law enforcement certification too early. I see too often that attorneys sent 1 letter to the police station, never got a response or got a denial, and that's it. They said, you know what, I can't help you. Well, let me tell you, police is not the only agency that can sign. So is municipal prosecutors, county prosecutors, judge, yes, prosecutor, but also Division of Civil Rights, EEOC, Division of Childhood Protection and Placement, formerly known as DIFAS in New Jersey. Any agency with investigatory authority can sign the certification. If you don't ask them, they're not gonna do it. So make sure you ask all of them before you give up. 5th, giving up, in other words, not filing because the abuser wasn't convicted. So assuming you were a victim of qualifying crime, right? That's step number 1. You reported it to the police and you assisted in the investigation. You meet the criteria even if the abuser wasn't convicted. Now, whether an agency is going to sign the law enforcement certification is a different story. But let me give you an example. Let's say you were charged with, so you were a victim of assault and robbery. Someone came in, attacked you, pulled a gun, stabbed you, what have you. You went to the hospital, you spoke to the police, you pointed out who they were, but the police never found them. Okay, so in that case, you can't speak to the prosecutor, you can't speak to the judge because the case never got to them. You can only speak to the police. But let's say they found them. So here's an example that I actually had. There was a workplace incident that was recorded. 1 woman attacked another. In front, the police were called, and then she attacked them again in front of the police. She was arrested. Now, she was released on bail, and then she disappeared. So she was not convicted, but it's not your fault. She has an order of arrest against her, and when she comes up, she's going to have to deal with it whenever they find her. Or let's say in that example, she's arrested, ICE picks her up because she has an order of removal, and she's deported. So she's never convicted of this crime, but because of what you did and how you assisted, a criminal was taken off the street. So that is sufficient for under purposes of the law. But again, if you don't request the supplement B, you're never gonna get it. In each of these scenarios, you can still qualify and achieve for U visa. When can I get my U visa result in a green card? Said another way, when can I get a green card after having a U visa? What are the requirements to get my green card? Well, first, you must have been continuously present in the US for 3 years with U visa status. That means no trip out of the US more than 90 days, and in total, not having been out of the US for more than 180 days. Now, it's better not to have traveled outside of the US at all. In order to travel, you need to file for advanced parole. I don't recommend it. If it's an emergency, you can do it, but they can give you a hard time trying to come in. It shouldn't happen, but the last thing you want to do is, after a 12-hour flight, show up at Newark or JFK, get turned around, and then have to litigate while you're outside the country. It's better to wait until you get your green card and then travel. If you do travel, you need to document when you left and when you entered. Alternatively, if your travel outside of the US was necessary to assist in the investigation or prosecution of the crime, you need a written explanation of that by a government official, basically on their letterhead saying, hey, this trip was in the furtherance of our investigation, because of your help, it resulted in someone's arrest and they were extradited to the United States to face charges for the crimes they committed in the US. Again, that's just an example. Now, second, so the first is you have to have been in the US continuously for 3 years. Third, you have not unreasonably refused to cooperate with law enforcement investigation and prosecuting the crime against you. Now, what that means is the Supplement B that was signed might have been signed before, let's say, the investigation was continuing but hadn't been charged with a crime yet, or the trial was ongoing, or you served as a confidential informant for a number of years and they helped you achieve legal status in the interim. Now, while that's going, you must continue to be helpful. But it has to be a reasonable request. And I'll talk about that in a moment. But here's a big one. July 31st, 2019, Immigration updated the Law Enforcement Resource Guide, which now encourages law enforcement to limit their issuance of these certificates or disavow them if you don't cooperate. Basically, it's no surprise, this administration is making it easier for you to lose your status and actually advising agencies not to sign certifications or to reduce when they reissue them. You may need a new Form I-19, a new Supplement B, with your green card as proof that you are a willing participant in the investigation or prosecution. You shouldn't require it. That shouldn't be necessary, but it wouldn't surprise me if we're going to start seeing some of those requests. You need to document each meeting that you have with law enforcement to explain how you've been helpful. Again, assuming it comes up. Now, if you refuse a request to cooperate, you will need to explain the reasons. For example, if the police wanted you to meet with the attacker who raped you, that would not be a reasonable request. That would be the opposite, an unreasonable request, and that is not a basis to deny that you're being cooperating. Third requirement. So again, first, you must have resided continuously in the United States. Second, you can't have unreasonably refused to cooperate. Third, your presence in the U.S. is justified on humanitarian reasons to ensure family unity or it's in the public interest. Green card is completely discretionary benefit. You must prove that you deserve it. You need to show your family ties to the U.S., achievement and accomplishments, and any reason you or your family would suffer hardship if you're returned to your country. Your accomplishments have to be particularly strong if you have criminal convictions. Fifth, you are not inadmissible to the U.S. because of participation in Nazi persecution, genocide, or other extrajudicial killings. Again, not commonly seen nowadays, but maybe more common in parts of Africa. Now, what if I married my spouse after I applied for my U visa? Can my spouse get a U visa or a green card? So here, what we're talking about, you were a victim of a qualifying crime, you received the law enforcement certification, you applied for your visa, and then you married to an undocumented immigrant, and you now want to get your spouse U visa status or a green card. Immigration refers to this as in after acquired spouse. Unfortunately, your after acquired spouse can't get a U visa through your process. In order to qualify, you must have been married before you applied. However, don't give up hope just yet. When you apply for your green card by filing Form I-485, or you already got it, your spouse could also qualify for a green card by filing Form I-929. That is a petition for qualifying family member of a U visa, non-immigrant visa. Your spouse's I-929 can't be approved until after your I-45 is approved. So if your petition is denied, hers will be also. You will need to show extreme hardship if she isn't allowed to stay in the United States with you, in addition to proving she's your spouse. So what we're saying is, you can't file for her to get a U visa if you got married after you filed. However, when you file for your green card, it's been approved or it's pending, either way, you can file for your spouse to also get her green card. In other words, she can skip the U visa stage, but there are additional requirements. You got to show extreme hardship to her, and of course, you got to show that it's a bona fide marriage. Now, how much does it cost to get a green card through U visa, and how long does it take? We start with the 3 questions and create a plan for you before we accept you as a client. We only want clients we can help. Do you qualify for a U visa through, so question number 1 is, do you qualify for a U visa or a green card through a U visa? Now, we just went over what those requirements are. Second, is there something in your past that can disqualify you, like multiple entries, prior denied petitions, criminal charges, removal proceedings? And 3, can we fix that problem, like a motion to reopen, post-conviction relief, or a waiver? If we can't do 1, 2, and 3, meaning if you qualify, but there's something in your past that disqualifies you, but we can't fix it, then we won't accept you as a client. We don't want to do anything that puts you in harm's way. One of our core values is we put you in a better position, in a better place than when you entered our world. That's why we do these 3 questions, to ensure that we can get you to the finish line. Because we focus on these 3 questions, 2 clients who are both filing for a U visa might have very different fees. In general, here's how we look at immigration fees, irrespective of whether you are filing for a U visa or you are ready for filing for your green card. We look at it the same way. Step 1, you're applying for a process. It's U visa or it's green card. We typically charge between $6,000 and $9,000 for that process, depending on the issues and that complexity that it presents. Second, do we need to order documents from immigration through the FOIA process, the 7 immigration agencies for prior border contacts, prior deportation, prior petitions that were filed? Third, do we need to order copies from criminal courts and a background search from the FBI? Because those are things that could disqualify you. Now, we typically charge $1,000 per person for the FOIA and the criminal background search. If there's something that makes you ineligible, we then have to fix it through a waiver, a reopening a criminal case, or reopening a removal order, or filing some other form of relief. The cost really varies, depends on what we do. That's a broad spectrum of stuff that I just threw at you. But generally, it's anywhere from $3,000 to $15,000. The more expensive one is usually when we reopen a criminal charge and we're charging you to defend you in that case. So we have to now do what you failed to do when you were initially convicted. It really depends on the severity of the charges you faced. Are you applying? So let's take a step back now, right? We have, so how much does it cost? We have a application process that's $6,000 to $9,000, including the supporting documents. Do we need to do a background search for you or for your spouse? And we charge $1,000 for each. Is there something in your past that disqualifies you? And can we fix it? If there is, then motion to reopen, post-conviction relief, maybe a waiver, and each one of those, depending on what the issue is, each one of those have a different price to fix it. And are you applying for just yourself, or are you applying for your spouse, or for your kids, or for your parents? Are they in the US, or are they outside, or is it mixed? Some are here and some are out. We typically charge a nominal fee to include kids between $500 to $1,000. If your kids or your spouse are outside the United States, there will be an additional fee for consular process, but that is only after the U visa is approved. Do your family members need a waiver? So we have to look at your situation. Do you have a path, something in your past that disqualifies you? And 3, can we fix it? And we have to have the same analysis for your significant other, parents or children. You know, do they qualify? Yes, as your derivative, or you got to get married in order to get qualified. Second, is there something in their past that makes them disqualified? And if so, can we fix it? Same consideration that we use for you. Now, waivers are usually only if they're in the United States, so generally speaking, if your significant other is outside of the US, she usually will not need a waiver unless she was here and then left and has been gone for less than 10 years. Again, every situation is slightly different. Every one of these things that I mentioned has a cost. It's for that reason that my assistants can't give you a price on the phone. It requires the knowledge and experience to figure out what needs to be done and what we charge for those services. Today, the U visa is taking over 4 years from filing to conditional approval. Then you can get work authorization, but it could take another 1 or 2 years until a visa becomes available. So it does take time from when you file to when you get a U visa to when you've had it long enough so that you can now file for your green card. As you see, the fees vary dramatically depending on your situation. But the good news is if you've had your U visa for 3 years, then you are ready to file for your green card. And be very careful here, because if you wait after 4 years from having a U visa, you're disqualified, and it's very hard to get that renewed. If we helped you with your U visa, then we already ordered your background search and won't need to do it again, unless you've been charged with any new crimes or you didn't request it in the first place. The petition itself is now to get your green card. Keep in mind, you've already had your visa. The petition to get your green card is usually $3,000 to $6,000 for Form I-45 and associated forms and proofs. Each member of your family will need his or her own form. We do discount if we are filing for multiple family members, because at the end of the day, it really depends on the victim. If you have an interview, and lately we are seeing almost everyone's getting an interview, we charge an appearance fee of $1,500 to go with you, to personally attend the interview with you. You shouldn't need any waivers because all those grounds of inadmissibility should have been dealt with at the U visa stage. However, if there are new issues, you didn't properly address them at that stage, the cost is $3,000 to $6,000. If you're applying for a family member that didn't previously get a U visa, again, think of after acquired spouse. So you're now filing Form I-929, that again is between $3,000 to $6,000. That family member would then need Form I-45, that would have another fee of $3,000 to $6,000 when the I-929 is approved. And that family member likely will have an interview, which would be another $1,500. So again, it does get complicated and it can get expensive. As you can see, the fees vary dramatically depending on your individual situation. But you don't need to worry because we do offer payment plans. We also offer discounts for those who pay in full, meaning in one payment. Now, we give discounts for repeat customers. So if we helped you with your U visa and you came back for your green card, we're going to give you an additional discount. The more money you bring with you to your consult, the higher the possibility of getting a discount on your immigration case. Also, if you need a payment plan, the lower your payment plan is going to be because you paid more of it up front. We give your case the priority that you do. The sooner you pay for your case, the sooner it gets filed. We typically need several weeks once we have all the documents, once you've answered all the questions, and you've paid in full to file your case. So again, the more money you can bring with you to start your case, the lower will be your payment plan, and the faster your case will be filed. Thank you for joining us. I'm Andres Mejer. Please subscribe to our channel and share this video with anybody you think needs information about how to get a U visa or how to get their green card from a U visa. Thank you.